Okay, I think we have both people here on the Connective Agency Texas LLC versus Jackson case.
Yes, Your Honor. How are you doing, Judge?
Good, how are you?
Good.
Ms. Fraser Lewis, are you there?
Good afternoon, Your Honor. How are you?
Good. Tony, are you ready? Tony, are you ready?
Okay, I just got back. I'm ready. Sorry.
All right. Let's go on the return on cause number DC 235148, Connective Agency Texas LLC versus Jackson. Counsel, make your appearances.
John Bernard Schwartz and Liz Branning here for Connective, the plaintiff, Your Honor.
Royale Fraser Lewis here for the defendant, Ms. Jackson.
All right, let's proceed.
Judge, we have some objections and a motion to strike that we filed that we think need to be heard before we get to argument in this case.
Okay.
We filed objections to defendant's evidence, and then today we had to file a motion to strike because opposing counsel or Jackson filed an amended answer and for the first time in this litigation pleaded the affirmative defense of consent. That was never part of their TCPA motion. It's time barred under the 60-day rule. I haven't had a chance to respond. My brief was due on the 21st. So these are two issues that are, I think, pretty important before for housekeeping before we get going on the case.
Ms. Fraser Lewis.
Your Honor, my TCPA motion actually does mention consent. Plaintiff actually objected to the section in his objections to evidence where it talks about consent. So it does mention it. And the privilege of consent is actually a part of plaintiff's plaintiff's case in chief. It's not a part of the defendant's. So defendant has affirmatively pled that no privileges apply because defendant did not know that the consent of a privilege applied.
Your Honor, I don't understand. I mean, we have two motions to strike, so there's a whole other evidentiary motion that we need to discuss. But on this issue of privilege, she's never pleaded the affirmative defense of privilege before Friday. She's never pleaded privilege. So if you look at my brief, it actually says as the elements for business disparagement and defamation, I have to disprove that there's any privilege or vice versa. It's not really clear in the case law, but I go forward on it. She never affirmatively pleads it. You have to plead and prove a privilege. The first time she pleaded it is in her amended answer Friday. So that's why I talk about it in my motion, because it's one of the elements of business disparagement and defamation, Your Honor, is privilege. So I have to say,
Ms. Fraser Lewis, I want to make sure I'm kind of understanding what you're saying. Are you saying that you're not pleading it as an affirmative defense?
Correct, Your Honor. It's an absolute privilege, and plaintiff is required to prove that it doesn't apply.
I've had no notice that she's pleading it, Your Honor. If you look at her answer, she says Miss Jackson is, and I'll share my screen, Your Honor.
I'm not going to consider this as an affirmative defense. If it's an element you have to prove, Mr. Schwartz, and it's an element you have to prove, she doesn't have to plead something that you have to prove. To the extent it's unclear in her answer, she's already affirmative stated, and I also ruled that there is no affirmative defense of consent being raised in this case. What's the other issue?
The other issue, Your Honor, is we filed objections to their evidence. She has multiple exhibits. I filed this on 8/21, and if I can share my screen, I'll show it to you, or the court can take judicial notice of it. It's August 21st. We filed motions where she has multiple statements in her pleading where she assumes facts not in evidence, and she has multiple documents attached as exhibits, though it's not clear what the exhibit numbers are unless you go to the bookmarks, but they were never proved up by affidavit, and Rule 166A applies, as Your Honor knows, and none of these documents are proved up. So if you look at my motion to strike, for example, exhibits A, D, and G in her original anti-slap motion should be stricken because they're never authenticated like they should be under Rule 166A. And this also goes to her reply brief, Your Honor. Again, She filed evidence with her reply brief that she filed on Friday on this issue of consent. She has evidence attached to it. So again, under Rule 166A, you would never be able to file new evidence as your reply brief. You can't do that. She wants to argue it. I disagree because she didn't plead it, but at the same time, she has evidence attached to her reply brief. And it's not authenticated and it shouldn't even be included. So again, that goes back to the other objection, but in this case, exhibits A, D, and G were never proved up. And then there's multiple statements in her brief that assume facts not in evidence and that are hearsay and that I map out in my objections, Your Honor.
So anything attached to the reply brief would be stricken because it is too late. But Ms. Fraser Lewis, what about the other exhibits?
Well, 166 AC and the Schlumberger case state that exhibits that are attached to a motion can be considered by the court. But specifically for A, D, and G, for A, our response is that under 1004, that the original has been lost, that it's in plaintiff's possession. That exhibit, I'm not sure if Your Honor has it in front of them, but it's the original job posting that Ms. Jackson referred to. So that would be in plaintiff's possession. So it would be our argument that it self-authenticates. For exhibit D, our argument would be under Rule 902B, plaintiff has had a reasonable opportunity to investigate. It's been on file for over a month. And that one specifically are the meeting agendas that were created by Ms. Jackson and sent to Ms. Chen for editing. And they include Ms. Chen's editing notes in them. And so again, the original for that one would also be in plaintiff's possession. And then for exhibit G, same thing. They've had a reasonable opportunity to investigate the authenticity. It's been on file for over a month, and the original is in Ms. Chen's possession. And then as for the most recent filings in my reply on Friday, one of them is a text message from a plaintiff's client that was sent last week. The original would be in their possession.
I don't know what 902E is, Your Honor. There's no such, can you?
I think she's talking about the rules of evidence, right?
No, I know. I'm looking at 902. There's like 902.1, which Ms. Royal Fraser, would you mind telling me again what your site is?
902B. There
is no 902B, Your Honor.
Texas Rule of Civil Procedure is 902B.
No, Texas Rule of Evidence is what you're looking at?
No.
There is no Texas Rule of Civil Procedure 902?
Yes.
There is no such
self-authentication.
That's Texas Rule of Evidence 902, and there's no such rule as 902B. There's 1B and there's 2B and there's 3B.
I'm looking at it right now, Your Honor.
It's a little, yeah, I see what she's saying. I think she's really citing to 102. Well, I'm not sure.
The Texas Rules of Evidence, Rule 902. And the B, if parties have reasonable opportunity to investigate.
Okay, it's 902.3B, Your Honor, and there's no good cause. She could have had Demisha just execute a simple affidavit of authentication.
Your Honor, I'm sorry, I didn't mean to interrupt you, Mr. Swords.
It's okay. That it's a true and correct copy. I mean, all of this stuff, she has multiple exhibits in her motion that I moved to strike because they're just simply not properly authenticated and they're hearsay. In this situation, this seems to be a document, I guess, that she's claiming was between Connective and her client. All she had to say was it's a true and correct copy in an affidavit. I mean, this is Rule 166A stuff. This is the basics of Rule 166A on display. This is not authentic. And this is not good cause. There's no good cause.
Okay, Ms. Fraser Lewis, go ahead, and then I'm going to say something.
The rule gives us this option for a reason, Your Honor. I can authenticate it by affidavit, or I can authenticate it this way. The original is in their possession, so I'm not sure why an authentication argument is being made when they've had notice of this for over a month.
How do you know it's in my
So
possession? How do I know it's
wait.
authentic? Yes, sorry, Your Honor.
So 902(3)(b) addresses foreign public documents. I don't think that it applies, it doesn't apply here. To documents that it purports to be signed or attested to by a person who then authorized by a foreign country's law to do so. And then subsection B, if there's a reasonable opportunity to investigate. 3B only deals with foreign documents, unless there's some other section you're talking about.
That may be correct, Your Honor. So I will.
So
state my argument.
let me just talk practically with you guys for a second here. What I would suggest, neither of you guys are going to like this, is Ms. Fraser Lewis, I would encourage you to, I would be inclined to continue this hearing, give you an opportunity to get an affidavit on file that proves this stuff up, because I think you need it. I will say this, Mr. Schwartz, is I've read this briefing, and I don't see, I think it's very likely that if this is properly proved up, I'm trying to be as transparent as possible. It's very possible that I will grant the motion to dismiss and award attorney's fees, because I really don't think your client has a claim here for business disparagement. And so unless you can show some kind of malice, or that these are lies, what she's saying, she has a right to do a Glassdoor, review. She didn't agree. She didn't like the company. I've gotten bad reviews. The Mexican food restaurant down the street's gotten bad reviews. We all get bad reviews sometimes. That's just kind of how the internet works. This is the type of case, I will tell you, I'm not a big fan of the TCPA, but I think this is the kind of case the TCPA was made for. And so you may have dodged a bullet here. If she had properly proved that up, I think I'd probably grant the motion to dismiss and award attorney's fees here. Since you have time, you may have time to reset this so she can prove this up. You may want to think about talking to your client about a non-suit. I'm just not ordering that at all. But Ms. Fraser Lewis, do you want an opportunity to prove this up properly? Ms. Fraser Lewis?
I'm sorry, Your Honor. I'm thinking, because it's our position that even if these affidavits, these particular attachments are taken out, they still don't have clear and specific evidence to meet their burden.
Your Honor, I don't think the TCPA applies. I mean, we have to get past that preponderance standard, and she cites to the statute in its pre-2019 state as her ground. She cannot meet her burden under the statute.
That's incorrect. My motion cites to the current statute. It also provides current case law that defines what a matter of public concern is. It does go into detail and includes some of the language from the previous statute, but the basis is the current statute, which is a matter of public concern.
Mr. Schwartz, I mean, I'm very familiar with the history of the statute. There was a lot of stuff, in my opinion, that statute was very abused. It was way too broad to begin with. And I think the legislature did the exact right thing to limit the statute. I think that even under the current statute, this is exactly the kind of case that the TCPA applies to. I mean, it's not the only kind of case, but it's the one we see by far the most often. I'm just trying to be transparent here. I think you both should listen to what I'm saying and take it to heart, but you don't have to. Not everyone does. I think you both did a great job of briefing this, and Ms. Fraser Lewis, I'd strongly encourage you to think about asking us to reset this. And Mr. Schwartz, I'm just telling you, I think you should talk to your client about non-suiting the case. That's just a suggestion, but it's not an order. We can go forward today if you want, and things may not work out the way you hope.
We would like the court to reset it.
All right, the court will reset it. I'll give you 2 weeks. Let's make sure. The 11th. Does that work for both of you?
I'm sorry, Your Honor, you said the 11th.
Yeah, does that work for everybody?
Your Honor, I apologize. I'm in mediation all day that day.
Okay. Do you want to be in person or remote?
Whatever the court prefers is fine with me, Your Honor.
I don't, Mondays are in person and Mondays are remote, Fridays are in person. So I could do the 18th, or if you want to be in person, we can do the 15th in the morning.
Your Honor, I'm available on the 18th. Oh, no, well, you said the 15th in person, Your Honor?
The 15th in person, the 18th is remote.
I can do either of those.
The
Ms. Frazier-Lewis?
15th would be better.
15th?
Yes.
Okay, that'll be in person in the morning. Does 9 o'clock work for both of you?
Yes.
Yes, Your Honor.
And
Ron,
to
did you get
clarify-
that? I'm sorry, I didn't mean to interrupt you, Ms. Frazier-Lewis. What were you saying?
Yes, Judge.
Ms. Frazier-Lewis was going to say something. I'm so sorry.
And to clarify, Your Honor, this is just for us to authenticate the evidence that plaintiff has objected to.
Right. And then you're briefing your other evidence that I struck in the reply brief would be good at this point. So I don't know how much overlap there is.
I'm sorry, I didn't hear what you said. The other evidence in the reply brief.
So in the evidence and reply brief, since we're moving it, you'll have a chance to respond to that. I'm just telling you what I think about the case. Hopefully we won't have this hearing, but if we do, you have a chance to respond to the evidence. So the 15th at 9 o'clock, Ron, did you get that? Ron, are you muted?
Yes, Judge. I have it on September 15th at 9 o'clock. Is 15 minutes long enough, or do you guys need a little more?
Your Honor, I did want to ask that this will answer the question about if 15 minutes is long enough. At the hearing, is the court only going to want to address the issues that were explicitly addressed in their reply?
It'll be we haven't really got to the hearing. I'll get to the meat. I've read all this. I kind of know what I'm going to do once it's all properly proved up, but I'll give it both sides an opportunity to argue it.
Okay. 15 minutes should be fine.
Okay.
All right, guys, you have a great rest of your day.
15 minutes per side, Your Honor. I'm sorry.
I was going to say 7 minutes per side, but if you want more time, we can give you.
Whatever the court has available. I just wanted to know how much time I have.
Yeah. We'll see you at 9 o'clock.
Thank you, Judge.
Thank you.
Thank you, guys. Okay, our next hearing is are both sides here on the Colin Brito case?
Good afternoon, Your Honor. Brian Deere here on behalf of DRB Capital. Mr. Colin Brito reached out to me earlier this morning and indicated he would not be joining us after he said he would be available on Friday. Just kind of a fair, the court requested a status update. I think procedurally where this case is right now, this is a proposed transfer of a structured settlement. It was initially assigned to I believe the 162nd District Court. We had indicated to comply with the local rules, send a communication to both courts to advise the courts that this case is subject to transfer to your court because your court heard the underlying judgment. And that's kind of where we are procedurally. Ms. Penson indicated that you wanted a status conference, so we're here.
It looks, oh, wait a minute, okay. All right, so it's really the 2312215. So yeah, so this case should be transferred to my court then. So
So we're just waiting for it to come to you and then we can move from there.
let me look that up real quick, Rhonda.
Okay.
What is the underlying case again? Is it 12115 or 12215?
It is, the underlying case is 2008.
No, the new case.
The new case, my apologies, Your Honor. It is, I believe, 12215.
Rhonda, we need to get an order transferring this case to us.
Okay,
Yeah, and I had previously did email to Rhonda a proposed order transfer, and so you should have one ready to go.
okay. Let me see if I got it, just,
You have it, Rhonda?
is what, cause number do you have it under, the old one or the new one? You
It's
remember-
under the old one, but I sent an email, I think, on August 22nd